elements, and the wages are fixed at different scheduled employments, different class of works in the same scheduled employment, adults and adolescents, children and apprentices, and different localities. Okay, so based on that, the wages will be fixed, the rate of wages will be fixed by the authority. So the minimum wage rate and the minimum piece rate, the guaranteed time rate, the overtime rate, all these are fixed by the government under subsection 2 of the Minimum Wages Act. Okay, so the appropriate government may refrain from fixing minimum rates of wages in respect of say any scheduled employment in which there's less than 1,000 employees who are employed in the whole state. Okay, so the governments will be trying to find the number of employees who are there in the concern, and based on that, if you try to fix up the minimum rates of wages payable to the employees by the employer. Now, what are the constituents of minimum rate of wages? So the minimum rate of wages fixed or revised may consist of the following. It can be the basic wage rate of wages, which can be adjusted in accordance with the variations in the cost of living. It can be a basic rate of wages with or without a cost of living allowance. And it can be the cash values of the concessions in respect of the essential commodities which are supplied. And these are supplied at a concessional rates, or it can be an inclusive rate allowing for the basic rate. So the procedure for fixing the and revising the minimum wages is dealt under Section 5. In fixing the minimum rates of wages in respect of any scheduled employment for the first time, or it is revising the minimum rates of wages by the appropriate, then the appropriate government shall appoint committees or subcommittees that may be necessary to hold inquiries and advise the government on fixation or revision. And it can also publish its proposals for the information of the affected persons in the official gazette. So it can be the committee procedure or it can be a notification procedure. So appointing committees and subcommittees would be a committee procedure, and the changes made through the notification can be the notification procedure. Any of the procedures the appropriate government can take into consideration when it is doing that. And coming to the provisions relating to the wages in kind of normal working day payment or overtime payment, etc. So all these are dealt here. So wages in kind is dealt under Section 11. So based on this wages in kind, what is wages in kind? As per the Act, the wages are required to be paid in cash, and it is customary to pay wages in wholly or partly in kind. So the appropriate government by notification in the official gazette authorize the payment of wages. Either it can be wholly or partly in terms of kind. And what are normal working days in regard to any scheduled employment of which a minimum rates of wages have been fixed under this Act? So the appropriate government may fix the number of working hours which shall be considered as a normal working day, inclusive of one or more intervals. And it can also provide a rest day with wages in every period of 7 days. So if you have seen Monday to Saturday, if it is working, generally Sunday is a holiday. So it is a paid holiday. You will get pay for the holiday. So in that way, after the very period of 7 days, there's a rest day, and provide the payment for work on a rest day at the rate not less than the overtime rate. So it should be a normal rate. And generally, overtime will be normal plus 1.5 times. So, I mean, in a way, you want to benefit for the overtime. Generally, the wages are paid at a higher rate. So, the payment of overtime. Now, the payment of overtime where an employee is on scheduled employment, works in more than prescribed hours of work, he shall be entitled to overtime wages. So, overtime can be the one who is going to get the wages as per the prescribed act. So wages of worker who works for less than normal working hours or working days if an employee whose minimum rate of wages has been fixed under this act works for a period less than the requisite number of hours in a day, then he shall be entitled to receive wages in respect of the work done by him on that particular day, as he had worked for a full normal working day. And he shall not be entitled to receive any wages for a full normal working day where there is a failure of work, or maybe the worker is unwilling to work, or maybe not, and this is not by the omission of the employer to provide him. It is solely from the employee's side, wherein he is not in a position to take up the work. Now, wages for two or more classes of work where an employee performs two or more types of work, to each of which a different minimum rate of wages is applicable. So such employer shall pay to such employee in respect of the time respectively occupied in each such class of work, or wages at not less than the minimum rate in force in respect of such class. Now, the minimum time rate wages for piecework where an individual is employed on a piece rate basis. So, the minimum time rate and not a minimum piece rate has been fixed under the Act. So, the employer will be paying to such an employee wages at not less than the minimum time rate. Now, coming to the maintenance of the records and the registers, it is mandatory, it is compulsory under Section 18 of the Act, wherein they have to maintain the registers and the records, and these should be at the place of work, placed at the place of work, and if any notices are there, any circulars are there, those should be exhibited, those should be on the notice board, wherein every employee or the worker or the working class should be knowing the details about the payment of the wages. And coming to the authorities and powers and procedures, the Act empowers under Section 7 that there is an advisory board which will be comprising of equal number of representatives of both from the employers and employees. And these people will try to coordinate with the work of committees and subcommittees appointed by for the fixing or revising the minimum rates of wages. So maybe the board will be trying to lay down the procedure, and they will try to help in discharging the functions under Section 5 of the Act. Now, we also have Central Advisory Board as per Section 8. So, the central government is empowered to constitute a Central Advisory Board for advising the central and state government in the matters of fixation, or it can be the revision of the minimum wages. And the committees and subcommittees under Section 9 will be specified that the advisory board and the committees or subcommittees shall be consisting of the persons only nominated by the appropriate government. So anybody cannot be a member of the committee. And the persons who can be appointed to these committees shall be a representative of the employees and the employers in the scheduled employment and shall be equal in number. Independent persons not exceeding 1/3 of the total numbers in such bodies shall also be appointed. Now, coming to the inspectors. So, inspectors under Section 19, subsection 2, they have the power to enter at all reasonable hours into any premises or into any place where employees are employed or they are working or the work has been assigned to them. And they have the power to verify, to examine the registers or the record of wages, or it can be any notice which has been exhibited on the notice board. And they can also examine any person whom he finds in such premises or a place, and they have a reasonable cause to believe like whatever the employee is saying. They might ask him any kind of such questions. And it also requires any person given out of work and any work to give any information which is in his power to give with respect to names and addresses of the persons from whom the work is given or it is being received. And also they have the power to seize or take the copies of such registers or record of wages or notice or portions which they feel that are relevant, and they can confiscate and they can take them with them for the verification. And if found guilty, they will be also, the inspector shall be deemed to be a public servant. So under such cases, under IPC Code 1860, he will be, any person required to produce any document or a thing or to give any information by an inspector under section 19, subsection 2 shall be deemed to be legally born. I mean, he is legally prone to do that particular work. And coming to the claims, now the claims are as per section 20. The appropriate government may appoint by notification in the official gazette an authority to look into the claims in respect of or payment of less than minimum rates of wages, and the employee himself or any legal practitioner or any official of the registered trade union authorized in writing by the employee, and the application for the claim shall be presented within 6 months for the date in which the minimum wages or other amount become payable. And if after hearing the application, the authority is satisfied that the application was either malicious or maybe it is not containing the details properly, it may direct that penalty not exceeding rupees 50 to be paid by the employer. So, whenever the authority finds it is not satisfied with the details mentioned, then this penalty not exceeding rupees 50 will be fixed upon the employer. This fine will be imposed by a magistrate. And every director of the authority shall be final. I'm sorry, every direction, the direction whatever given by the authority will be final. And every authority shall have all the powers of the civil court under the Code of Civil Procedures 1908 for the purpose of taking evidence. And coming to the powers of central and state governments, which are dealt from section 26 to 30, there is an exemption. The central and the state government have the power to direct that the act shall not apply to disabled employees or any other class of employees, and such periods and such subject to such conditions as may be notified by the government. And the state government, to add to the schedule, in case of the state government, is of the opinion that the minimum rate of wages can be fixed or should be fixed by any employment. It can do so by amending the schedule by a notification. And the central government to give directions. The central government is empowered to give directions to a state government for carrying into any execution of the act in the state, as well as the central government has power to make rules, and the appropriate government has also powers to make rules for carrying the purposes of this particular act. Coming to the liabilities of the employers, now the section 11 says that employers shall pay the minimum wages payable under the act. Either it can be in cash and shall pay the wages in kind as notified by the appropriate government. And the employer shall make provision for supply of essential commodities which are genuinely to be given at concessional rates as notified and computed the value of the wages. And coming to the section 12, once the minimum wages are notified and become payable, the employer must pay to every employee the wages at a rate not less than the minimum rate fixed by the government. And section 14, the employer shall pay overtime wages for every hour of work or part of the hour at the rate prescribed under the Act or under section 59 of the Factories Act 1948. You have section 18. Every employer shall maintain the prescribed registers, record, giving particulars of employees who are employed with him. Okay, then the details of wages paid to them, the receipts given to them, he needs to maintain a record. And the employer shall try to exhibit at the place of the employment the work notices in the prescribed form with the prescribed information, and I mean, it should be dealing with all the categories or all the necessary categories of employees who are working. And the employer is also required to furnish an annual return in form number 3 by the 1st of February of the succeeding year. So he is supposed to submit a return stating the details of the payment terms and the payments. And even the wage slips, I mean, the employer should also have the wage books or the wage slips in the prescribed form, which mentions the name of the employee, his employee identity number, and the amount paid in cash and kind. And in this way, we have the conditions coming to the penalties or offenses where there is a claim by an employee and is found to be malicious, fine up to ₹50 payable to the employer. And if the payment of wages is less than the minimum rate fixed by the government, appropriate government, then there's an imprisonment up to 6 months or fine up to ₹500 or both. And the contravention of any rule or others made in respect of normal working hours, the same fine up to ₹500 and imprisonment up to 6 months. And then we have the contravention of any provision of the act or rule or under where no other penalty is provided, a fine up to ₹500 will be charged. Coming to the miscellaneous provisions, the correction of errors, the appropriate government may at any time by notification in the official gazette correct the clerical or arithmetical mistakes in any order, fixing or revising the minimum wages, contracting out any contract or agreement, whether made before or after the commencement of this act, which deprives the worker of the minimum wages fixed. And it can be the bar of suits. No court shall entertain any suit for the recovery of the wages, which is subject of application for claiming pending before the authority concerned. So this is all about the payment of minimum wages. Now coming to the next subheading, it is Payment of Bonus Act 1965. So apart from the wages, a bonus act has also come into the picture. Now, what is a bonus? It is the profits which are distributed amongst the workers is called as a bonus. It can be considered as a gift, or it can be an ex gratia payment by an employer to his employees, and it can be in terms of cash or kind. And generally, the bonus is paid to the workers to motivate them to give some kind of happiness or satisfaction that they have earned something more. And during the First World War, 1917, the textile industry in Bombay and Ahmedabad, they gave 10% increase in the wages, and they called it as a war bonus. And this increased to 15% in the year 1918. And during the Second World War, the bonus again became a live issue when industries started making extraordinary profits. So what is the need for the act? So bonus in the beginning was considered as an ex gratia payment, and as such was considered a derogatory form from the point of view of the workers. So it is not an ex gratia, it is the profits. See, they work 200%, they put their efforts to the maximum, and then they give the employers the profits or the production. And rightful owners are the employers, but when you see, it is the employees or the wage holders who are the rightful owners to take a share from the profit. So the derogatory term of ex gratia, they did not like, and they felt that it is the profits which exceed a certain level. And once the level has been crossed, every worker deserves a share in the profits, what the organization has earned. Now, coming to the objective of the act, the term bonus is neither defined in this act nor under any other law. So, bonus Commission of India, appointed by the Government of India in the year 1961, they said that it is difficult to define the rigid terms, the concept of bonus, but it is possible to urge that once profit exceeds a certain base, labor can legitimately have a share in the profits. So then we see that there is an enactment in Article 43 of the Constitution, which says that there is nothing wrong in the endeavoring to do so, wherein they share their profits with the workers. Now, coming to the object of the Payment of the Bonus Act 1965 is to provide for the payment of bonus to the persons employed in certain establishments on the basis of profit. Now, the scope and applicability of the act extends to whole of India. It provides that the act shall be applicable to those establishments employing 20 or more workers uh, employed on any day during the accounting year. So the appropriate government by notification in the official gazette can make a provision of the act applicable to any class of establishments specified therein, including factories. Now coming to the definitions, accounting year means it is an year of 12 months. It is a period of 12 months preceding from the last date to the first date. And whenever we say financial year, it starts on 1st of April every year and ends on 31st of March next year. Now coming to the allocable surplus. Now, what is it? It means that in relation to the employer being a company other than a banking company, which has to make the arrangements prescribed under the Income Tax Act for the declaration and payment within India for the dividends payable out of its profits in accordance with the provisions of Section 194 of that Act. 67% of the available surplus in any accounting year, in any other case, it is 60% of such available surplus is called as allocable surplus. And the appropriate government, it can be the central government, and in relation to other establishments, it is the state government. Available surplus, it means the available surplus computed under Section 5 of the Act. Award means an interim or final determination of any industrial dispute. A company means it can be an Indian company or a foreign company as defined in the Companies Act 1956. And a corporation can be any body corporate established by or under any central, provincial or state, central, provisional or state, and does not include a company or a cooperative society. And employee means any person employed on a salary or wages not exceeding rupees 10,000 per month in any industry to do any unskilled or skilled or managerial or supervisory. It can be technical, clerical, administrative. Okay, so all these come under the employment when it is implied to express. Coming to the employer means a person who has a factory or a place or an occupier or owner of the factory. It can be including the agent. So, and in relation to other establishments, the person who are or have the authority to control over the affairs of the establishment. So, he is called as an employer. Salary or a wage means all the remunerations other than the remuneration in respect of overtime work capable of being expressed in terms of money, which would be paid. So, it can be the payment, the money or the monetary thing which is paid to the employee, and it also includes dearness allowance and all the cash payments by whatever name you call it, and it does not include any other allowance which the employee is for the time being entitled. The value of house accommodation of supply, like supply of light, it can be water, medical attendance, or any other amenities, or any travel concession, any bonus, including incentive, production, and attendance bonus, any contribution paid or payable by the employer to any pension fund or provident fund, any retrenchment compensation or any gratuity, or other retirement benefits payable to the employee, or it can be any commission payable to the employee. So excluding this, the dearness allowance and the salary and any other thing which is paid in the form of cash to an employee is called as a salary, excluding these 12 points. Now coming to the eligibility for bonus, every employee shall be entitled to be paid by his employer in an accounting year bonus in accordance with the provisions of this act. So he is entitled in the establishment for not less than 30 working days in that year. So he should be working with the establishment for a minimum period of 30 days. Now coming to the disqualification of bonus. An employee shall be disqualified from receiving bonus if he is dismissed from the service for any fraud, any violent behavior, or any theft or misappropriation or sabotage of the property. So if any of these things have been done, then he is not eligible for a bonus. And coming to the payment of minimum and maximum bonus, the minimum bonus is defined under Section 10 of the Act, and it states that subject to the other provisions of the Act, every employer shall be bound to pay to every employee for an accounting year a minimum percentage to be 8.33 of the salary or wage earned by the employee. Or 1,000 rupees, whichever is higher. So it can be 8.33% of the salary or wage, or it can be rupees 1,000, whichever is higher. And if the employee has not completed 15 years of age at the beginning of the accounting year, the provisions of the section shall be effected in relation to such employee. For the words of 1,000 rupees, the word 60 rupees were substituted. Okay, so here, if it is not a major, he's not a major, he's only 15 years, he's not completed 15 years, he's a minor. Under such cases, the 1,000 rupees would be the bonus. And coming to the maximum, which is dealt under Section 11. So, wherein in any accounting year, the allocable surplus exceeds the amount of minimum bonus payable to the employees. Under that section, the employer shall be, in lieu of such minimum bonus, be bound to pay to every employee in respect of that accounting year, and the bonus which will be equivalent to the proportion to the salary or wage earned by the employee during the accounting year. So it should be a proportional bonus where that would be the maximum amount under Section 11. Now coming to the calculations, it should be minimum of 8.33% and a maximum of 20%. And where the salary or wage of an employee exceeds 7,000 rupees per month, the bonus paid under Section 10 or 11 shall be calculated as if the salary or wage was 7,000 per month. Even if it is exceeding, the bonus will be calculated considering that the wage or the salary is only 7,000. Now, proportionate reductions in the bonus in certain cases where an employee has not worked for all the working days in any accounting year, the minimum bonus of 1,000 rupees or the case may be of 60 rupees. And if such bonus is higher than 8.33% of the salary or the wage for the days he had worked in that accounting year, shall proportionately be reduced. So if the worker or the employee has not worked for full term period, then accordingly it will be reduced. And computation of the working days. So an employee shall be deemed to have worked in an establishment in any accounting year, so for which he has been on leave with salary or wage. He has been absent due to temporary disablement caused by the accident in the course of his employment, or it can be a maternity leave, or the employee has been laid off under the agreement, standing orders agreement, whichever is applicable. Based on that, he has been laid off. So under such circumstances, the computation of the working days will be taken based on the worker who shall be deemed to have worked in the establishment. Now coming to the set on and set off of allocable surpluses dealt under Section 15, where for any accounting year, the allocable surplus exceeds the amount of maximum bonus payable to the employees, then the excess shall be subject to the limit of 20% of the salary or wage. So it cannot exceed the maximum wage. Whereof in any accounting period, there is no available surplus or the allocable surplus in respect of that year falls short of the amount, the minimum bonus payable to the employees in the establishment under Section 10. So there is no amount or sufficient amount which can be set carried forward or it can be set on, will be utilized for the purpose of the payment of minimum bonus. And the principle is set on and set off as illustrated in the 4th schedule and shall be applicable to all other classes. Now, coming to the adjustment of customary or interim bonus, wherein in any accounting year, an employer has paid any payment of bonus or other customary bonus to an employee, then or the employer has paid a part of the bonus payable under this act to an employee before the date on which such bonus becomes payable, then the employer shall be entitled to deduct at the amount of bonus so paid from the amount of bonus payable by him to the employee under this act. Now, coming to the deduction of certain amounts from the bonus, this is dealt under section 18, where in any accounting year, an employee is found guilty of misconduct causing financial loss to the employer, then it shall be lawful for the employer to deduct such amount or such loss from his payment. So, coming to the time limit of payment of bonus as per section 19, where there is any dispute regarding the payment of bonus pending before the authority, the act, section 22. So all the amounts payable to an employee by way of bonus under this act shall be paid in cash by his employer within a month from the date of the award from which it becomes enforceable or it comes as a settlement in operation. And in any other case, the bonus shall be paid within a period of 8 months from the close of the accounting year. And coming to the authorities and duties, so Section 5 of Schedule 3 of the Industrial Disputes Act 1947, it tracks the provision of the industrial disputes. So as per this, the industrial dispute can be dealt by either by the Labor Court, Industrial Tribunal, National Tribunal, or it can be the arbitrators, or it can be the inspectors. Now, coming to the inspectors, the appropriate government may by notification in the official gazette appoint such persons who thinks fit, who can be acting as the inspectors for the purpose. So here the inspectors have the power to ask the employer to furnish any such information which they may consider necessary. They may enter the establishment at any given time. They can verify the books of registers, they can verify the papers, they can verify the documents, they can verify the pay slips, payment of salaries, wages, and other bonus. So all these documents, they have the power to verify. Okay, and then they have the power to make copies or take extras from any book of the register. They can extract it, they can take the copies, and they can also exercise such powers which may be prescribed. And every inspector shall be deemed to be a public servant when it comes to the payment of the bonus. And any cognizance of offense, so under the jurisdiction of regional labor commissioner or the central government, or not below than the rank of the labor commissioner in the case of an officer of the state government. So they have authorized in the behalf of that government, and no court inferior to that of a presidency magistrate of the first class shall try any offense punishable under this particular act. Now, protection of action taken, section 31, no suit or no prosecution or any other legal proceedings shall lie against the government or any other officer of the government for anything done in good faith or done to be done in pursuance of this act. Now, coming to the liabilities of the employer, section 4, 5, 7, 14, they they come under the primary liabilities, which wherein you compute the gross profits and the available surplus, calculate the direct taxes payable by the employer, and complete the number of working days with regard to the employees. And section 19 deals with the timely payment of all the amounts by way of bonus. Section 26 deals with the preparation and maintenance of records in the prescribed manner. And Rule 5, Form D, submit an annual return of bonus paid to the employees during the year. And Section 25, Subsection 2, to get the accounts audited as per the directions of the Labor Court or Industrial Tribunal or any other authority specified. And Section 27, Subsection 2, A, B, C, D, they deal with the compliance with the requirements of the instructions issued within the powers of the inspector specified in this act. Now, coming to the penalties for offenses under this act, If any contravention has been done relating to the provisions of the Act or the rules, that is the rules made under this particular Act, an imprisonment up to 6 months, a fine of ₹1,000 or both may be levied. And if there is any non-compliance of the directions or the requisitions made, it can be 6 months imprisonment and fine up to ₹1,000 or both. And failure to get the accounts audited as directed by the Labor Court, Industrial Tribunal, or any authority specified, then the expenses of the audit shall be paid on default, recoverable from the employer. And then you have the miscellaneous provisions, calculation of amount payable as bonus. So as per the Act, it has laid down a detailed procedure for the calculating of the amount of bonus payable to employees. So for these purposes, the gross profit is calculated as per first or second schedule. From this gross profit, the sums are deductible under section 6 are deducted. So based on this, the calculations has to be done. And to this figure, we add the sum equal to the difference between the direct tax calculated on gross profit for the previous year and the direct tax calculated on the gross profit arrived after deducting the bonus paid or payable. And so we arrive at the surplus available. On this surplus, 67% in case of any other company other than a banking company, and 60% in case of others will be considered as allocable surplus. And how do you compute gross profit? The gross profit in case of a banking company can be calculated in the manner specified in the first schedule, and in any other case, it can be calculated in the manner specified in the second schedule. So what are the deductions from the gross profit? Any amount by way of depreciation, which is admissible in accordance with the provisions of the Income Tax Act, agricultural income, and income tax law, as in the case may be prescribing. And the direct tax payable by the employer, every company has to pay the direct tax. So, and any loss has been incurred, even that has to be filed in the income tax. It's not that only the profits and the taxes are paid. And what are the losses which the company is carrying forward for the next year as per the enforcement of the direct taxes, and any areas of the depreciation which the employer is entitled to add to the amount of the allowances. So such things has to be calculated. And the employer is a religious or charitable institution in which the provision of section 32 do not apply. That is, the depreciation part do not apply, and the income is exempt from tax. And where the employer is an individual or HUF, the tax payable by such employer under the Income Tax Act shall be calculated on the basis that the income derived by him from the establishment is his only income. Now, the computation of available surplus. So, whatever the available surplus is there, that will be referred under section 6. So, the gross profits of that accounting year after deducting from the sums referred to in section 6, and any amount equal to the difference between the direct tax calculated and the provisions of the section 7, in respect of an amount equal to the gross profit of the employer, which is calculated immediately preceding the accounting year, will be considered. Now, what is the meaning of an establishment? Section 3 of the Act provides that the word establishment shall include all the departments, undertakings, and branches wherever it has to be situated. And such things will be called as an establishment. And this is how the Payment of the Bonus Act deals. Now, coming to the next subunit, we have the Equal Remuneration Act 1976. Now, the principle of the equal remuneration is based on that the men and women workers will be considered as equal. Okay, and in generally, the normal tendency is that male are paid or men are paid more than female. And when it comes to children, the children's payment is, that is the adolescents, or what do we say, the child laborers, they are paid a different rate of payment. So here, when we are talking about the equality, equal pay for equal work, wherein it aims to provide the payment of equal remuneration to men and women. And here I mean to say about the remuneration is nothing but the basic wage or salary or any other additional emoluments, whatever payable. Either it can be paid in terms of cash or in kind. Now, coming to the need of the act. Now, as I said, in our country, men and women are discriminated, and even a child is discriminated based on it. The payment of wages and all other acts have come so that they can bring equality in the payment of wages. So Article 15 of the Constitution of India provides for prohibition of the discrimination on grounds of religion, race, caste, sex, or place of birth. And Article 39 of the Constitution envisages that the state shall direct its policy among other things towards securing that there is equal pay of equal work for both men and women. Now, coming to the objectives and scope of the Act, the Equal Remuneration Act 1976 provides for the payment of equal remuneration to men and women workers for the same work or work of similar nature, and there is no discrimination. And it also stops the discrimination between male and female employees while making the recruitment. And coming to the commencement and applicability of the Act, so it has come into the force on such date, not being later than 3 years from the passing of this Act, as the central government may, by notification, appoint, and different dates may be appointed for different establishment of employments. So when it comes to the sections, you can see that Section 2A one of the Industrial Disputes Act 1947 to any industry carried on by or under the authority of the central government. Under the industrial disputes, it is carried on under the authority of the state government. Under Section 2J of the Industrial Disputes Act, industry, it can be Section 2KA of the Industrial Disputes Act, wherein the establishment, and under 2S of the Industrial Disputes Act, workmen. So the Act shall not apply in certain special cases which are as under, that is Section 15, when special treatment is given to women employment under any law or to any special treatment accorded to women in connection with the birth of a child. Section 16, when the central government or the state government makes a declaration that the difference with regard to remuneration on a particular species of remuneration of men and women in any establishment or employment is based on factor other than sex, that is gender. And coming to the definitions, the appropriate government means in relation to the employment, it can be the central government, and in any other case, it can be a state government. Men and women mean male and female human beings, respectively of any age. When it comes to the remuneration, it can be the wage or salary or any other additional emoluments which are payable. And then you have same work or work of similar nature. It means that work which is in respect of the skill or effort or responsibility, sorry, required are same. And a worker means a person who works in any establishment or employed under employment terms in respect of this particular act. So, Act to have overriding effect, Section 3 of the Act provides that the provisions of the Act shall have effect notwithstanding anything inconsistent therewith contained in any other law. Either it can be in terms of award or agreement or contract. Now, coming to the equal remuneration to men and women workers, no employer shall pay to any worker remuneration payable in cash or in kind at rates less than the favorable than those paid to workers of the opposite sex. No employer in compliance of Section 4(1) of this Act has above shall reduce the rate of remuneration to any worker. And where prior to the commencement of this Act, the remuneration payable to the workers was paid at different rates on ground of sex, that is gender, the higher rate or the highest rate, whatever has been paid to male and female employees. No discrimination while recruiting men and women as per Section 5. Employer, while making the recruitment for the same work or work of a similar nature, wherein the skill or the efficiency required, on any condition or service subsequent to the recruitment, such as promotions, training, or transfer, shall not make any discrimination against women except where the employment of women in such work is prohibited or restricted or under any law for the time being in force it is applicable. So other than that, there is no such discrimination which can be dealt by the employer. Now, coming to the authorities and their duties and powers and procedures, if you see, there is an advisory committee. Now, this advisory committee has been appointed under the appropriate government, and they might appoint one or more committees to advise regarding the extent to which the women may be employed in such employments or establishments. Okay, and coming to the authorities for hearing and deciding claims and complaints, Section 7 of the Act empowers that the appropriate government may appoint such officers not below the rank of labor officers as it fit things to be the authorities for the purpose of hearing. And we have inspectors under Section 9. So the appropriate government by notification appoints such person as it may think fit to be the inspectors for the purpose of the making of an investigation. So what are the powers of the inspectors? They can enter any premises at reasonable time if it thinks fit, and they can inspect any documents, any registers. They can examine any worker, by talking to him and gathering the facts. They can take on the spot or otherwise the evidence of any person, examine the employer or any other person found in charge in the establishment. And they also have the authority to make copies and take the documents with them if they find anything malicious. And the liability of the employers is dealt under Section 8. It is the duty of every employer to maintain registers and other documents wherein they are employing the workers. And the cognizance and the trial of offense is dealt under Section 12. No court inferior to that of metropolitan magistrate or judicial magistrate of the first class shall try any offense punishable under this Act. And no court shall take cognizance of any offense punishable under the Act except upon its own knowledge or upon complaint made by an appropriate government or an officer authorized, or a complaint made by a person aggrieved by the offenses. It can be the social welfare institutions, or it can be the recognized institution who on behalf of the central government or the state government may file a petition. And coming to the penalties and offenses, failure to or omission or to maintain any document or documentary evidences or the registers in case of the employed workers. So the fine might be up to rupees 10,000 and there's an imprisonment up to 1 month. Sometimes it can be both. And failure or omission to produce any register or document relating to the employment, the same punishment as above, 1 month imprisonment and 10,000 rupees fine, or both. So omission or refusal to give any evidence or preventing preventing his agent, servant, or any such person in charge for the establishment, the same fine up to rupees 10,000 or 1 month imprisonment, or it can be the both. Make any recruitment in contravention of the provisions of the Act, imprisonment up to 1 year. And this might be extended up to 3 months, from 3 months to 1 year, and a fine of rupees 20,000. And that is the maximum amount, 10,000 to 20,000, or it can be both. And making any payment or remuneration or making any discrimination or omission to carry out the directions of the appropriate government, or omission to produce records to the inspector. So for all the things, except for the last one, for the rest of the things, the maximum amount of penalty or fine would be 20,000 and the maximum period of imprisonment might be up to 1 year. Whereas refusal to produce the documents to the inspector, the fine up to rupees 5,000 might be levied. So offenses by the companies, where an offense has been committed by a company, every person who is in charge will be considered as a responsible person of the company, may be given the, I mean, it can be considered as an offense whenever, when it is dealt by a company. And so whoever is in charge, whichever person is in charge, who can be considered as a responsible person for the company for the conduct, shall be deemed to be guilty, and the offense has been committed by him. Okay. And the miscellaneous provisions are the recovery of monies during the due from the employer. So section 33 will try to comply with that, where they try to recover the money, and it can be the company, it means any body or corporate, a director, a person in relation to a firm. It can also be a partner. And what are the powers of the central government? They make the rules, they make the provisions which are to be carried out by the rest, so that there is uniformity and there is no discrimination which is generally done on the basis of the gender. And coming to the powers of the appropriate authority, where the appropriate government, on consideration of all the circumstances of the case, is satisfied that the difference in regard to the remuneration on a particular species, that is, it can be the remuneration paid to men or women workers in any establishment or employment, is based on the factor that they will be considered equal. And if the appropriate government may, by official notification in the Gazette, make a declaration to that effect, and may act, and any act of the employer attributable to such difference shall be deemed to be a contravention to the provisions of the Act. So this is what all about the equal remuneration. Now coming to the legislations on the social security. So under social security, we have Workmen's Compensation Act 1923, Employees State Insurance Act 1948, Employees Provident Funds and Miscellaneous Provisions Act 1952, and the Payments of the Gratuity Act 1972. We also have the Contract Labor and the Regularization and Abolition Act 1970 and the Maternity Benefit Act 1961, which are all considered as social security. And coming to the first one, Workmen's Compensation Act, I think we have time only to deal with the meaning. So we will just complete that today. So the industrial development has increased where it comes to the machines have increased, the manufacturing process has increased. And I mean, it also has led to a lot of industrial accidents, and which led to sickness, industrial sickness or disablement, accidents or deaths. So this is the case where we find that there should be some kind of a compensation which has to be paid to the worker whenever it is a loss of a limb, or it is a disability, or sometimes in case of a death, where the entire family, the dependent family, will be served some kind of a compensation where they can have their livelihood. So the Workmen's Compensation Act 1923 is enacted and issued by the central government. And this was implemented by various state governments, which has given rise to the social security to the workers. So why is the requirement of this act is there, need for the act? So before the enactment of the Workmen's Compensation Act 1923, it was very common for the employers to pay some kind of a compensation voluntarily to workers, either for sustaining an injury, or it can be any particular small accidents while they are on duty. But this is not a general practice, and because there is no law to this record, so most of the workers, they fail to get any compensation from the employer for the injury what they have I mean, while they were on duty, they were performing their duty and they were injured. So, whatever the compensation is paid, also, it is only out of the generosity where the employers voluntarily come forward and pay some amount as a compensation to the injured. So, the ever increasing intensity and the complexity of the industrialization or the mechanization or the rationalization, automation, all these has caused the industrial accidents very frequently at every stage, and this is where the necessity for the act of compensation has came into picture. And the result was the enactment of Workmen's Compensation Act 1923, which is now known as Employees Compensation Act 1923. Now, coming to the objective and the scope of the act, the Employees Compensation Act is a Social Security Act, and it imposes statutory liability upon the employers to discharge their moral obligation towards their employees. Either it can be the diseases what they derive while work, or the disability, or it can be the death in sometimes, because they work in such an environment which is not healthy at all. It is hazardous, it is not clean, there is no proper air. Okay, air and ventilation, the workers, they work in such an environment. So it is the obligation or the duty of the employers to take care of the employees. So under such cases, we have the Workmen's or the Employees Compensation Act 1923. Now, coming to the commencement and the coverage of the act has came into force from 1st of July 1924, and it covers all workmen who are engaged directly or indirectly, and it is not applicable to the causal workers or persons not employed for trade and business by their employers and members of armed forces of the Union. Now, coming to the applicability, the Act applies to certain categories of railway servants, workers employed in any capacity under specified, which is specified under Schedule 2 of the Act. And it also includes factories, mines, and plantations, mechanically propelled vehicles, construction work, and certain other hazardous occupations. So there is no age limit for the coverage of workers under this Act. The Act does not, however, apply to persons whose employment is of casual nature. They are not permanent employees, and they are employed only for a purpose of a trade or a business. Persons serving in armed forces, and workers covered by the Employees State Insurance Act 1948. So apart from these three, the rest are covered. Now, coming to the definitions, a dependent means any of the following: a widow, a minor legitimate or adopted son, an unmarried legitimate or adopted daughter, or a widowed mother, wholly dependent on the earnings of the employee at the time of the death, a son or a daughter who has attained the age of 18 years and who is infirm, and if wholly or partly a part of the dependent on the earnings of the employee at the time of the death. It can be a widower, a parent other than a widowed mother, a minor illegitimate son, an unmarried illegitimate daughter, or a daughter legitimate or illegitimate or adopted if married, and a minor, or if widowed and a minor brother or an unmarried sister, a widowed sister if a minor, a widowed daughter-in-law, a minor daughter of a predeceased son, a minor child of a predeceased daughter where there is no parent of the child is alive, and a paternal grandparent if no parent of the employee is alive. So it is paternal in the sense from father's side. So this is the definition of what do we say, the dependent. So the rest of the definitions: employee is a person who has been employed under the terms of Workmen's Compensation Act. And employee means who is a railway servant. It can be a master, a seaman, or a member of a crew of a ship, a captain or other member, a person recruited as a driver, helper, and a mechanic or a cleaner, a person recruited for work abroad by a company, and employed in any such capacity as per the Schedule 2 specifications. And employer is a person a body, incorporated, any managing agent of employer, legal representative of the deceased employer, or any person to whom the services of the employee are temporarily lent. A seaman is a person who is forming a part of the crew of a ship, but does not include the master of the ship. Wages, the term wage includes any privilege or a benefit which is being paid in terms of money other than the traveling allowance or the concessions paid by the employer. And coming to the disablement. So it is already 2:33. So I stop here. Yes, Vaishnavi and Karthik, if you have any doubts, maybe you can just ask me.
No, madam.
All right, we'll continue from disability definition in tomorrow's class. Okay, thank you.
Sure. Thank you, madam.
Thank you, ma'am.